My journey in getting a USA trademark. There's a bigger story to how this happened. I'd been learning a lot about intellectual property as part of protecting my work as a designer. I started out looking into getting Amanya as a trademark in the UK. I was doing the research myself, speaking to the intellectual property office, and I spoke to lawyers with the half-an-hour free time they offered. At a key time, I saw someone I'd not seen since school. She introduced me to her husband, who was a trademark attorney. I shared with him what I was planning to do, and he advised me my plan needed a few tweaks, so I made those adjustments. I spent time going to meetings and networking, looking to see if there were funding opportunities available. That's where I met some people from the Department of International Trade, now called the Department of Business and Trade. I was at a stage in my business where I was starting to work on print on demand for the first time and develop my own design ranges. Print on demand means products are produced as they are ordered, so I didn't need to be concerned about lots of stock, storage, and distribution. My designs were going on lots of products, so this meant my trademark needed to cover a lot of the areas called classes, which meant it would be expensive. This process wasn't going to be cheap for me. Before that, I'd been providing services as a designer to companies, but this was a new addition to my business plans. The textile industry I'd trained in hadn't got the work opportunities that it used to have, so I ended up working part-time doing admin work to help fund my design income. I hadn't established my brand in the UK yet, and certainly wasn't ready for export, but didn't want to turn their help down. There was some funding available for me to export if I had a plan they wanted to approve, so I thought, let's go for it. And I started putting together an international business plan. I was needing to pay for a new website anyway, and I could ask for half of this to be covered by the bid money. The DIT introduced me to many people that were expanding my business ideas and plans. I was working long hours alongside my part-time admin job to get this new business plan ready for the funding application deadline. And to my greatest surprise and delight, I ended up getting the funding approved. One of the requirements was to be moving into international markets, so I applied for a US trademark to cover the possibilities for trading in the USA, and a Chinese trademark due to plans to start producing my designs in China with one of my business contacts. Although the bid would cover half the costs, it was still very expensive. Many months passed. Then I had an email from WIPO, the World Intellectual Property Office, to say my Chinese trademark had been refused. By that time, the plans for production in China had failed, but I still didn't want to lose that money. I called my trade advisor, who set up a call with a UK trademark attorney to ask his advice. He put me in touch with a senior intellectual property officer in China. He looked into the application and told me it had failed on the grounds of a lack of distinctiveness. He advised me I could consult a trademark attorney with Chinese expertise to help me with it, but he said it may not help due to the grounds of rejection. That was £1,625 down the drain. More months passed. Then I had an email from the USPTO, the United States Patent and Trademark Office, to say my trademark had a provisional full refusal. I got back in touch with my UK trademark contact to ask his advice. He gave me details of his contact in the USA, a trademark attorney, to advise me. He looked at my application and told me it was likely it could be resolved, but he'd need to help me as I wasn't based in the USA. I couldn't do it alone. The USPTO require foreigners outside the USA to have a US attorney to represent them. It was decision time. Did I let the US trademark fail and lose all I'd spent, or did I pay the attorney the money to help me? I did not have the money spare, so it was not an easy decision to make. But I decided that I would go for it rather than seeing more money go down the drain with nothing to show for it. The US attorney took over and communicated with the USPTO examiner on my behalf. They came back to me with questions and things I needed to amend. It wasn't a straightforward process. The trademark attorney's costs clocked up, but we had done it. I had a USA trademark on the principal register.